What is it about cute or funny videos of children that gets people hooked? It's relatable, it's entertaining, it's educational, but is it dangerous? Hi friends, I'm Kay. I'm a lawyer for content creators, and this is the Creator Cafe. In this video, I will break down some recent creator news and highlight the key legal takeaways to help us all make good business and legal choices online. Also, I am a lawyer, but I'm not your lawyer, and this video is not legal advice. Our infatuation with the lives of influencers has created a new legal crisis for children. Did you know that a parent in the US can legally force their child to be recorded and shared online without that child's consent? And in general, that parent can make money using photos and videos of their child without sharing the profits with that child. The truth is, most child influencers have no legal rights to the money made from videos that feature their lives, their faces, or their intimate or even embarrassing moments. They have no legal path to make their parents stop. Sometimes family vlogs are done super well. The kids seem happy, it doesn't feel forced or performative, and they seem to be sharing the wealth of their labor as a family. But what we see is an edited version of real life. Today's tea is about a new child influencer law that we all need to pay attention to. It could have major consequences for how we share and consume content featuring children online. Let's start with some context. I want to talk about child labor. Seriously, because if we're going to talk about legally protected child influencers, we need to define them. Are they working or not? And if they're not working, then what are they doing? If you, like me, had a job when you were 15 or 16, you were protected by federal or state child labor laws. You probably didn't work past 9 p.m. or for more than 4 hours on a school night. This is because back in 1938, Congress passed a comprehensive federal labor law called the Fair Labor Standards Act. This law, among other things, regulated the working conditions for children, including setting rules for what age of minors could work, how many hours at a time, and what types of work they could do. Whether you were lifeguarding or scooping ice cream, your employer was probably obligated to comply with those standards. However, like so many laws, the FLSA has exceptions and loopholes. There are whole categories of work that were excluded from the many legal requirements set out by the FLSA. When we think about child influencers, the closest existing profession may be child actors and performers. However, the entertainment and acting industry was exempted from FLSA, meaning child actors were not and are not protected by that law. Instead, each state must decide what labor laws they will enact to regulate the working conditions of child actors in that state. California has the most well-known child entertainer law called the Coogan Law. This law defines and protects child actors, requiring that a portion of the child actor's earnings be placed into a trust fund that only they can access when they turn 18. This is to prevent parents from stealing the money made from the child's work. The law also included things like requiring work permits, setting limits and working hours, and requiring educational and study time for child actors. So, FLSA, Coogan's Law, what does this all mean for child influencers? Well, not much. Child influencers are not employees or workers or child actors that qualify for protection under most existing labor laws, at least as of June 2024. This means that if parents want to monetize their kids' image, likeness, photos, videos, that this action is not legally considered to be employment or other working relationship that would trigger the traditional labor protections for that child. Which brings us to July 1st, 2024, a low-key historic date as Illinois is officially the first U.S. state to expressly protect minors who are featured on social media and other online platforms. So what kind of protections are we talking? As of that date, child influencers under the age of 16 in Illinois would be entitled to compensation. Yep, that's right, just money. They won't be protected in terms of working hours, working conditions, taking breaks, or being paid minimum wage. Maybe that will come later, but for now, let's talk about how minors in Illinois must be compensated for their role in online video content. And if you think this law may apply to you, I urge you to work with an Illinois licensed attorney that can provide you personalized legal counsel. Under the new law, children who are featured in compensated video content are legally entitled to a portion of the revenue earnings made from that content. How do you calculate what that portion is? Parents must keep track in writing of how often and for how long their child's name, likeness, or image is featured. This includes both visually and in audio of the content. Let's do a quick example. Imagine a family YouTube channel based in a suburb of Chicago. To simplify, it's a single mom, Valerie, and one single child. We'll call her Olivia. Valerie is now required to set aside a portion of the gross earnings from video content that uses Olivia's name, likeness, or image in a protected trust account for Olivia to access when she turns 18, or sooner if she's emancipated. The amount that is required to be set aside must be at least half of the percentage earned from the video content that includes Olivia's name, image, or likeness. For example, if Olivia is featured or discussed in 100% of Valerie's compensated video content, then 50% of the gross compensation must be set aside. If Olivia is featured only 50% of the time, then 25% of the gross compensation would need to be set aside for her. That's the basic calculation. And hoo-hoo, for the family vloggers, if multiple minors are in the video content, the percentage that is set aside is calculated based on the total time all minors are in the content and must be split equally among accounts for each minor. So who does this apply to? I have a public Instagram and I share photos or videos of my girls sometimes. What if I lived in Illinois? Would the new law apply to me and my occasional posts of my kids? Here's 2 criteria for when the law applies. First, you look at the time featured. If the percentage of time that a child's featured over a 30-day time frame is 30% or more, then the law applies. This is not a one-time calculation, it's a rolling 30-day calculation. The other criteria for applying this law is the money earned. If the number of views received per video segment on a given platform meets that platform's threshold for compensation, or if the vlogger received actual compensation equal or greater to 10 cents per view, then the law applies. You can see how both the platform's payouts as well as paid partnerships can trigger this law. This law has some exceptions and nuances. On its face, this law appears to cover content that is performed in the state of Illinois, which begs the question, if I'm a family vlogger who lives in Illinois, but I cross the border to film all of my content in Indiana, can I use that as a loophole to not comply with the law? Also, the law seems to apply only to video content. Seemingly, vloggers could opt to monetize their children's name and image via photo sharing without triggering the law. Lastly, and maybe this is obvious, but the law does not apply to minors who create and share their own content. Although Illinois is the first and only state to actually pass a law like this, there are several other states who have begun to follow suit, including Georgia, Ohio, Missouri, Maryland, Arizona, and California. Some of those proposed laws use similar language as the Illinois law. Some even go a step further by adding legal protections around working conditions and hours. I'm sure you realize that most of what I'm talking about relates to the labor and compensation of child influencers. There are so many issues, for example, the right to privacy, which apparently children don't have in these cases. Also, consent. Can a 5-year-old really agree to be recorded and shared on YouTube, a concept she couldn't possibly comprehend? Last, but certainly not least, what about the child's mental health? I, for one, am glad that my childhood was not broadcasted online. And while most parents would say that they know what's best for their children, even a parent's instinct can be compromised in the face of a potential income source. But to be clear, I don't personally think it's immoral or unethical to post your kids online. As long as you're mindful of their privacy, their willingness to be engaged, I think there are endlessly creative ways to share your children without compromising their safety. I'd love to know. What are your thoughts? Share them in a comment and let me know if there are any other influencer legal topics that you'd like to see me cover in a future video. Thanks for watching. Please like and subscribe if you're into it, and come back soon.